Thank you, Mr Chairman. Ms Nelson, if there's any danger of us running past 4 p.m, we'll need to break at 3 p.m.
Thank you, Commissioner. Could I have a document on the screen, CRW 709-132-1836 at page 2, which is the one on the screen. You see that's an email from Mr Connolly to yourself, Mr Murray and Mr Preston.
Yes.
Mr Connolly states it's shameful how poor Hume avoids my calls.
That's from Mick, isn't it?
Yes.
Yes.
How often did you talk to him on the telephone in 2014?
As and when the need arose. And as to why Mick was calling me on that occasion, I'm not quite sure. Clearly I was very busy and had other things I was attending to, otherwise I would answer his call.
And he refers to having a sleepover in Jurien Bay in the second paragraph.
Yes.
If you could just scroll up to see your response, thank you.
Yes.
Was that email exchange indicative of the familiarity between you and Mr Connolly?
Not at work normally, but that was an exchange that did take place, a bit of banter between my fellow colleagues and me.
When you say not at work, you were very familiar?
Not ordinarily, but outside of work we would talk about anything about life. Beyond work.
Did you arrange social occasions during work time?
Well, it looks like we have, yes.
And during social occasions, did you talk about work?
No.
How can you be so sure?
That was, several things come to mind. We're all very professional. Secondly, we didn't need to talk about work. If I needed to talk about work to Mick or any other officer within the department, I had access to them via email, phone calls, any time during the day, 5 days a week.
Thank you. That can be taken down, and that's from 2014. Do you recall during 2015 that you, Mr Murray, Mr Preston and Mr Connolly exchanged several emails about boats for sale?
I remember Mick had an interest in boats, and Claude did too, but I can't remember the specific emails now. But there was, I do recall, odd photos of boats for sale coming up and various dreams about owning such a big, large boat.
And you mentioned before lunch that there was also some exchange about skydiving.
Yes.
Did Mr Connolly give you a voucher to go skydiving?
No, I bought that myself.
But you went with Mr Connolly?
We were up there fishing at Jurien Bay and we booked it the week before. Or
what year was that?
As a guest, 2017-ish.
And after Mr Murray approached Mr Preston and Mr Felsted about his and your relationship with Mr Connolly,
yes,
which was sparked by the initial fishing trip invitation by Mr Connolly,
yes.
Did Mr Preston or Mr Felsted ever suggest to you that your communication with or socialising with Mr Connolly should stop?
No.
Did they ever suggest it was inappropriate?
No.
Did you ever have any discussions with Mr Murray or Mr Preston or Mr Felsted about any possible benefit to Crown in managing the casino licence if you maintained a friendship with Mr Connolly?
No, nor was that my expectation.
Was it their expectation?
Not that I know of. They never raised it with me, and if they did, I wouldn't accept that position.
Do you accept that it did assist the relationship of the casino licence operator? You had that relationship with Mr Connolly, who was the
I think the fact
CCO?
I had knew of quite a few officers within the department, including Mick, made my ability to communicate with them easier because I knew of them for many years, knew a lot of them for many years.
And if your ability to communicate with him was easier, then it was easier for you to, in effect, portray the Crown submission in the best possible light for getting changes to policy.
No, the submissions were drafted out and stood on their own merits. I made a point, as I said earlier, of the executives signing those documents because they are the ones that take charge of these matters. I'm simply the conduit by which the business asks me to prepare submissions.
If the submissions stood on their own merits, why was it necessary for you to have informal meetings with Mr Connolly prior to submitting those letters?
Okay, the informal meetings were often driven by two things. A request for us to demonstrate a product, but it wasn't just him. There was a lot of other officers that were invited and did attend. One of the ladies sitting here today was one of those officers, attended presentations, submissions to supplement maybe what the written submission was. It wasn't unusual for matters which were important that Crown would be requested by the Commission to personally attend, and the executives and the General Manager at times did attend and do a PowerPoint presentation to talk to the Commission members.
Isn't it the case that before the DRGL operations meetings that Mr Connolly would come and have a meeting with you in your office?
Not every time, no, but there was occasions he did that, yes.
And
Not every meeting.
So what was the purpose of those pre-meeting meetings with Mr Connolly?
Sometimes he asked me what's this about, because bearing in mind the agenda would go to the officers of the department before the meeting. He just wanted me to give him a bit of a heads up, if you like, what that matter was about. Secondly, he may have had something to talk to me about, like from a submission perspective. More generally than not, it was only a matter of 5 or 10 minutes before the meeting, and it was just a general chit-chat, how you going? It wasn't for hours or things like that.
So it was part social and part work?
Yes.
Did you ever give Mr Connolly any gifts while you were at
No.
Crown?
No.
Are you aware of any other Crown executives or management giving Mr Connolly any free meals or alcohol or tickets to events?
Not that I know of, no. The only thing, and I think I've mentioned my statement, is that when there's 3 instances that I recall where, if you call it a gift or a benefit, where they had morning tea and biscuits and cakes at the end of the year meeting, and the Commission members would also attend the Crown Perth once a year, but no gifts as such.
What about any other Crown employees, any other department employees?
No.
Were they given any bottles of wine?
I didn't have authority to authorise that. I didn't have that level of, to commit to any expenditure, so no, I didn't.
Did Mr Preston have that authority?
Yes, Mr Preston, Mr Murray did, and other managers at that level.
Were you aware of Mr Preston giving any free bottles of wine to department employees attending at the restaurants?
Not that I know of.
A review of the relationship between yourself and Mr Connolly, and also between Mr Murray and Mr Connolly, was commenced by Crown in February 2021, so this year.
Yes.
And it was coordinated by the Chief Risk Officer and Seegers. Were you aware of that review?
Yes, I had been contacted by Claude before that review, saying that Helen Coonan, was it, had wanted an internal review conducted of the relationship between myself and Claude, and he said, would I be willing to participate in an interview with somebody? And I said yes. I did speak to and meet with a person called Nick Caldis. He's, as I understood it, an ex-Deputy Commissioner of Police from New South Wales or Queensland or something. So I spent probably an hour or so with him. I subsequently was advised that a lawyer was intended to be appointed to do that review. I can't remember whether Claude told me that or it was following my meeting with Mr. Blaxall and Mr. Lilly. At that stage, I didn't commit to doing that. I decided, given that I thought this matter would be considered at the Commission, I'd rather just talk about it here than with anyone else.
Thank you.
But I was told of the name of the fellow that was going to do that. He was a lawyer, if I recall correctly.
Now, I just changed tack and want to ask you about junkets and the department's approach to regulating junket activity.
As in the Department of Race and Gaming?
Yes,
Yeah,
so
okay, yeah.
going way back to
Yes.
1985 and
Yes, 88.
up to 1998.
Yes.
Were you? Did you have a role in regulating junkets when you were at the department?
The only role I had was certainly as an inspector, we were asked to participate at the buy-ins and the settlements, just to observe the transactions that took place and the payment of the commission relevant to those gaming activities. Later on, as I mentioned, I developed, along with others, a risk-based program associated with junkets. That was based on the legislation in place at the time and the various other processes around the Commission approving junket operators, if I recall correctly.
So at the time that you put that risk-based audit program in place, what was the position in relation to regulation by the department? What did the department have to approve?
The junket operator and the junket representative.
So they never had to approve the junket participant, is that correct?
No, that's correct. Yeah.
And what information did they have at that stage? So this is in mid-90s.
Would you like me to walk through the process as I recall it?
Yes, please.
Okay. So the Commission determined to put, I think it was around 88, regulations in place in terms of junkets, because that's when Burswood, who was potentially one of the first casinos in Australia starting to bring junkets in, they put regulations in place which have now been removed, as you probably know, in 2010. Those regulations required the junket operator and their representative, but junket operator principally, to fill in an application form, filling out all the personal particulars that were necessary and detailed in that form. The junket operator, if I recall correctly, was permitted a one-off visit, even though they hadn't been approved. The purpose being for them to attend an interview with, I don't even know who did those interviews back then.
Someone from the department?
Yes, somebody from the department, and I couldn't tell you who. And then following that interview, there was also a series of police checks done, if I recall correctly. And in some instances, the junket operators themselves had to provide a police clearance certificate from the country of their origin. Once that junket operator is approved, they can obviously bring more players in for subsequent visits. A junket representative also had to be approved. There had to be an appropriate authority signed between the junket operator and the junket representative, detailing what steps that representative can perform on behalf of the junket operator. If I recall correctly, that was a requirement of the Commission, although it's not written anyway. I know that was a requirement of the Commission. And the way they went. And obviously there was junket audit programs in place which the inspectorate would have utilised and presumably still utilise until recently, observing junket activity.
So it was a one-off approval process?
That's my recollection, yeah.
Now, then fast forward to, you mentioned 2010.
Yes.
Were you involved in the submission from Crown to the GWC to get those amendments through in 2010?
I was, yes. I was approached, do you want to jump in? Yeah, sorry. I was approached by Josh Preston, asking if I would prepare a submission to the Commission. There was some difficulty, as I understood it, from junket operators coming to WA, whereas in Melbourne, and I understood other jurisdictions, they had laxed the requirements to be approved, or as I understood it in Melbourne, were licensed.
Where did you gain this understanding?
From Josh, and I was aware that that's what had happened in Melbourne, even though he mentioned it to me because I'd been speaking to somebody else. He then and I just briefly talked about the role of other authorities, such as immigration, customs, in allowing these countries in. We talked about 9/11. We would have thought they would have put a robust processes in place in checking the integrity. So I went about drafting a letter. I jumped onto, if I recall correctly, the websites of those authorities, which are listed in my letter, and I actually used some of the text on their websites, which talked about what they do and how they communicate between one another, to include within the letter. Also, having been familiar with the processes that have gone on in the past in approving junket operator, I was very conscious that the Commission give junket operators a one-off approval and never did any further review. So that was put in the letter as well.
And apart from a conversation with Mr. Preston, did you seek advice or information from anyone else before you drafted the letter?
No. As in another delivering customs or immigration or anything like that?
Or anyone else in Crown?
No. I just did. Josh was the primary point of contact for me. I did, of course, speak to the AML people about their processes, because he raised the due diligence processes that the AML team does. So the series of points that you will see in that letter is information I gained through the AML team at the time.
And is that the AML team that was in Perth at the time?
Yes. Only ever dealt with Perth people.
I'll get the letter up, which is GWC.004.008.001. In front of the letter is actually the submission to GWC.
This is the Commission meeting agenda paper?
It is.
Yes.
I did send that to you to read yesterday.
I did have a quick read through, yes.
Now, apart from seeing it yesterday, have you ever seen that document before?
No.
We could go to page 12, please.
Just on that, I do recall having lodged that submission, I received a call from an officer of the Commission and said he'd cited or seen our letter, and that he was of a similar view, and that he had put a paper up to the Commission some 5 years earlier, and at that time, I think it was 5 years, at that time the Commission didn't support his recommendations, which was similar to what we put in our letter.
Was that an officer of the Gaming and Wagering Commission or the department?
I don't know whether he's still an officer of the Gaming and Wagering Commission. I think he might be, but he's certainly an officer of the department.
Right. Can you recall his name?
Nick Toyne. Again, I'd worked closely with Nick. Nick was actually in my team for a number of years.
And apart from that one phone call with someone from the department, do you recall speaking to anyone else from the department about
I never spoke to anyone else other than I think it was Santo Menino and possibly Sandy Del Preti in regards to the processes around the regulations being amended that I can recall.
Okay, so we've got the letter of the 4th of December 2009.
4th, yes.
And it's addressed to Mr. Michael Connolly, Acting Chief Casino Officer.
Oh, so he wasn't the Chief Casino Officer at the time. Somebody else might have been. He must have been acting in that person's role.
And is this the letter you say that you drafted?
Yes.
The first paragraph says we refer to the most recent discussions between Mr. Joshua Preston, yourself, you, meaning Mr. Connolly,
yes,
and Mr. Del Prete.
Yes.
Was that a meeting or was it discussions one-on-one?
No, a meeting. Ordinarily, meetings until more recently were held at Crown Perth. Over time, we started sharing because the regulators' time pool. We would drive into the city and meet them in their offices. But yes, it would have been a one-off meeting with all the parties concerned.
And what
And,
other...
and it sounds like there was more than one because I've got discussions.
Okay. You can't recall now how many meetings there were?
No, I can't. And it might be a meeting as well as telephone discussions, a combination of those.
Do you agree, well, first of all, yesterday did you familiarise yourself with the contents of this letter again?
Yes.
And do you agree that one of Crown's essential arguments in the letter that you've written is to discontinue junket regulation because the entry process into Australia through the visa application process of the Department of Immigration was sufficient to exclude organised crime?
And the fact that I was aware that the department, once it had approved a junket operator, didn't do any further inquiries, unlike your casino employee licence or your driver's licence where it's renewed. Those two stand out to me.
And you've also mentioned before, I brought the letter on the screen, that there was some AML compliance
yes, and those elements too, yes. Sorry.
explanation that you gave. In the letter, you also say that Crown, in their AML CTF program, was reviewed yearly by the audit department and every second year by an external auditor.
Could I go to the next page? But I do remember reading that because that's what I was advised. Yes. That's what I was advised that occurs.
That's
And
the
I met-
last point on 0013. The AML CTF program is reviewed yearly by Burswood's
Yes.
internal audit department. Did that occur to your knowledge?
I'm not sure. I may have spoken to the internal audit manager, again, because she sat close to me as well, to glean that information or confidence, but I can't recall.
And you also say each alternative calendar year by an external auditor.
Yes.
Did that occur?
Again, I'm not certain because I didn't have a lot to do with AML. This is information fed to me by, as I think all along I've said, anything I prepare beyond information that I'm aware of, I source from the various departments.
That can be taken down, thank you. In your statement, which is wit.0010.0001.0011 at page 11, at the top of that page, you're talking about the submission in relation to table game supervision. But you say it can confirm information contained in the written submission sent to GWC was provided by
Sorry,
various...
I'm just missing that paragraph.
Sorry, it's right at the very top. I'm going a bit fast.
In this matter relates to amendment to directions relating to... Yes.
So I gather that you're saying there, in relation to table games, that you gather information where necessary for the letter to go to GWC.
Yeah.
But you don't necessarily have any independent knowledge that what you're saying in the letter is true and correct.
Look, that letter was a fairly extensive letter. There was information that was brought to my attention and Sasha Gris, because we were the preparers of that letter, from finance, surveillance, security, if I recall, table games.
If I could just stop you there,
Yes.
I will take you to that letter. I
Yes.
just want to ask you about your process
Oh, yes,
by
okay.
which you draft the letters.
Yes. So I draft the letters, I look at the information they give me, I often query information, certainly with some of the information we were getting from various departments in this particular submission, as to their accuracy, and I got them to double check stuff, as did Sasha. My instincts thought it was right because it looked reasonable, then I would go with it. Otherwise, I just wouldn't have the time to go around personally checking and getting all the data myself.
And is that the same for that letter of the, I can't remember the date now, but back in 2010 that we've just looked at for the junkets, the submission to the GWC?
Yes. So all that AML information would have come from the AML team, I'm certain. As I said, I jumped on the web pages of those various government agencies involved in government aid, in immigration and that, and other stuff that was there.
Thank you, that can be taken down. And when you were involved back in the department days with setting the order programs for junkets and attending to the settlements and the other duties that you've described, why was it at that time that the department wanted to regulate junkets?
I wasn't privy to knowing why the Commission made that decision, to be honest with you. It was just something, the regulations came in and away we went. So that was, I wasn't even at head office, as we call it then. We were working shift. So there was the Chief Casino Officer, and the Commission members. So I mean, I can second guess, but you want the truth, I want the facts, I would have thought.
Well, in setting the audit program for junkets, did you need to understand the perceived risks that the department were trying to regulate?
Again, I presumably we did. The audit program, I think, still exists, and those risks would be still there. I know the audit program was there before I left because I remember seeing it, the junket program. Whether it had been amended in my time whilst I was away to reflect new different things, I don't know. But we're talking back many years ago. I couldn't give you a definitive answer there.
So it's your understanding that the department still has a risk program, an audit program for junkets?
I would see no reason why they wouldn't want to take an interest in that side. Certainly, there's a philosophy that it's only gaming, and I use the word only, but the integrity of gaming is important. But I used to compile a report the first 10 months when I came back for the chairman and the commission members, detailing all the junkets. I noted it had fallen off the radar, so I started resurrecting that when I got back. Whether that still happens, I don't know.
So in 2010 or 2009, December 2009, when Mr. Preston came to you and said that he wanted you to draft this letter to the GWC or to Mr. Connolly to get rid of the regulation over junkets.
Yes.
Did he have a conversation with you as to why he wanted that to occur?
Oh, yes, yeah. He talked about what happens in Victoria. He said that from the information he'd been given, junket operators that would ordinarily, because you've got to bear in mind, a lot of business was driven by people based in Melbourne. Perth, as I understood it, the junket operators were unwilling to come to Perth because if they had to go through a interview process, an application form, they'd rather just stayed in Melbourne or go elsewhere to another jurisdiction. And that's how he described it to me.
Did Mr. Preston, sorry?
And bearing in mind these people are from a different country where I suppose law enforcement may be viewed differently.
Was there any discussion between you and Mr. Preston about any potential link between junket activity and money laundering?
No, nothing.
Did you ever have that conversation with Mr. Connolly at any stage of your relationship?
No.
Did Mr. Connolly discuss with you the attitude of the GWC to junket regulation at any time?
No. In fact, I'm just trying to recall. whether Mick saw this thing through or he had left by that stage, because I seem to recall correspondence came through from Santo, another senior manager, so I'm not sure, but you'd know better at what time he was there or not.
The letter stated at the end that Crown would continue to advise the GWC of new junket operators and representatives.
Yes.
And did that occur?
Because that was what I think part of the discussions. My understanding is it did continue for a while.
For how long?
I did receive a call from Sandy Del Preti, if I recall correctly, saying that we won't need that information any longer.
Sorry, he said what?
I thought he said the department didn't need that information any longer.
What year do you think you received that call?
Oh. A few months later, maybe 3-6 months.
So still.
But I may be mixing that up with his call to me about not sending through the revenue packs that came through. So I had so many phone calls about different things. Look, whether it's continuing now, I couldn't tell you.
If someone from the department had rung you asking you to no longer send in
Yes.
junket information,
Yes.
is that something that you would document?
Yes,
in
I
writing?
would send an email out to the relevant parties that would do that, and that would be through to David Brown in the cage.
So it was David Brown's job otherwise, until he received that email, to send that information to the department?
Yes, was it junket settlements, was it? Just remind me.
We'll go back to the letter and have a look.
Please.
It's
Because there was two departments involved in this.
GWC.0004.008.001, and it's at page 14. Thanks. It's the very last paragraph.
Okay. So in regards to the first part, immediately advise the Commission of the appointment of new junket operators and junket representatives. That's a matter dealt with by the international team. In regards to details of junket...
The very last paragraph, Commissioner.
Thank you.
Would you like me to go through that again?
Yes.
So there's 2 points to that particular paragraph. In regards to the appointment of new junket operators and junket representatives, that was managed by the international team, and we had managers at Crown Perth at that time that were actively working with Crown Melbourne in that space. So they would have been the persons ordinarily sending that information. In regards to the settlements, they would be derived from the cage because the junket settlements were conducted at the cage. And David Brown would be, and his staff would be the persons involved in that.
So do I understand your evidence to be that at some point after this letter, that practice was continued
Yes,
by the international team and by Mr. Brown and his role as general manager of the cage?
that would be my expectation, yes.
So it's your expectation, but
Yes,
did you have
'cause-
knowledge that that practice was put in place?
I think it was still in the manuals at that stage.
And is it your evidence that at some point after this letter, Mr. Sandy Del Prete contacted you
Yes.
about discontinuing both aspects?
Again, I'd have to refer back to the procedures that exist today. Yeah, I'm a little vague in that area.
Okay. And if you received a call from a department officer saying we no longer need you to do something
Yes.
that had been in a submission letter from Crown to the GWC, would you require that to be in writing from the department?
It would be nice to have it in writing. Unfortunately, you may notice in the minutes of the meeting where matters were put before the Commission, either formally or through presentations, there was not always a letter of approval or in principle approval. that was one of the prime reasons for the operations meeting, because they documented that we had been advised of, yes, proceed with that matter.
Thank you. Could we have a letter from Mr Preston to the Chief Casino Officer from February 2017, CRW.709.132.6189. Do you recall drafting this letter?
I do now. That's one of those matters I think I corrected in my statement. I didn't recall what this was about. Yes.
And is it correct that this was about Crown proposing amendments to the casino manual in relation to junket procedures arising from the regulation amendments that had occurred in 2010?
Yes. So, again, going on memory, there was a lot of procedures within the casino manual relevant to junket, and I seem to recall Mick calling me saying, "Paul, why are these procedures still in there?" So I looked them up, and as I said, these procedures have ownership by the relevant departments, albeit I endeavoured to try and keep a handle on them. So it was obviously an oversight. So we went about removing, I think, all of those procedures. Removing the requirement junket operators to be licensed or approved. Now, I use the word licensed because I've noticed in a lot of letters from the regulator, in the documents you send me, they talk about licence, but they were never licensed, they were only ever approved. And maybe a distinction there, but...
So it's your evidence that this letter arose from a telephone call you received from Mr Connolly, not from anyone else within Crown?
I think
That's right.
you said Mr Toy. I thought you said Mr Toy.
Mr Connolly in this instance.
Oh, right, okay.
Mr Toyne is relevant to the...
Oh, sorry, I misheard you.
All right.
Thank you for correcting me there.
Oh, I hope I didn't say Mr Toyne. It can be a bit
I probably
dyslexic.
just misheard you.
Was there anything else that was happening at the time that prompted this action apart from a call from Mr Connolly?
I can't recall.
And do you recall that you then proceeded to engage with Mr Connolly and with the redrafted manual? I'll show you a document, CRW.708.008.7829.
Oh, now I remember what you... Yep.
So we're now in March.
Yes, yes.
And if we could go to page 7, thank you.
Yes. So they were, again, going on memory, the new casino manual. We were slowly moving sections from the various manuals that were in place into the new casino manual operations. So at that time we took the opportunity to include procedures in that new section 28, I think I thought it was. It wasn't unusual whenever Crown made a submission of any sort, be it a game, new game, rules, procedures, and as you'd expect, the regulator to review them and come back and say, hang on, that doesn't read well, or can you add this or that? And that was part of the ongoing, and has been that way since day one, the casino, where they would give us input as to what they wanted, what they didn't like, even ideas to improve things, which is very helpful.
But it was Crown's role to draft the casino manual.
Yes, it was always Crown's role. In fact, yeah, in the early days I was involved in reviewing the first casino manual that came in from the Genting at that stage.
Thank you, that can be taken down. Were you aware that Crown assisted some international patrons to obtain visas?
I didn't get too involved, but I had heard that there was some letters or communication to support players or junket operators, but I wasn't involved in those sorts of things.
But you had enough of the awareness of the situation to know that the assistance was in the form of letters.
Yeah, that's what I understood.
To whom?
To whatever authority, immigration, customs, or whoever was seeking. I don't know if there was many, but I had heard that we had supported one or two or something.
Only one or two?
I seem to recall there might have been one or two occasions that might have occurred, because I think I queried, what the heck are we doing that for?
When did you query it?
When I heard about it.
And when was that?
Or maybe 5 years ago.
It's about 2016 or 2015?
14, 15, 16, yeah.
And why did you say, what the heck are we doing that for?
Look, I have a view that that regulatory authority has a role to play. I didn't know where we stood in giving somebody that, I don't know how well we knew them, to start giving a letter of reference, if that's what it was. I think you have to be very careful when you start doing things like that.
Who was giving the letter of reference from within Crown?
I really don't know who signed those letters. I just had heard that that's what might be happening.
And did you become aware towards the end of your time at Crown that the Commonwealth Law Enforcement Integrity Agency was doing a inquiry into that practice?
No, I didn't.
You didn't know that?
Didn't know anything about it. Who are they again? Sorry?
Ackley?
Ackley, okay.
Had you heard of Operation Angove?
No.
On the 16th of April 2014, do you recall that you and Mr Preston sent a letter about amending the casino manual concerning the exchange of gaming chips?
At gaming tables?
Yes.
Could I see the letter? But I do remember it.
Yes, it's DLG.8.001.0022.8435.
Could I just see the next page just to make... Yes, look, I'm familiar with this one, yes. Yes, yes.
And at the time, was there a prohibition on the exchange of gaming chips between tables unless there was certain criteria?
It wasn't a prohibition, it's just the way things were done. All movements of chips from the chip bank were through... forget the chip bank itself, but all movement of chips from the chip bank to tables was done through fills and credit documents. They were a computer-generated document through Psycho. Historically, they were a manual document. This came about because table games management raised with me, with Josh, on a number of occasions, and even with security, the delays experienced in getting the correct chips to a table. If you can imagine, a dealer's got an inventory tray about this big with a set number of denomination of gaming chips. There's need at times to pay out somebody a particular amount, but those chips might have been depleted. So it would require the big boss having to go back to the computer system, request a fill, goes through, prints out at the chip bank. The chip bank clerk's busy doing everyone else's because there's all these pits requesting transactions. Then the need to call a security officer, and then the need to notify surveillance before they moved.
So there was a delay in gaming.
Yes. So the idea was to, without affecting revenue, and again, this is an example of where I had several inspectors come down and walk them through what we were planning to do. seeking their approval.
Is there a reason why the letter's addressed to Mr Michael Connolly but it has attention Mr Mark Beecroft?
Yes, there is a reason. That's Mick started saying, because there was a point in time which I don't wish to disrespectful to the regulator, but it seemed things were just, people weren't sure who was managing what in the department. We had a lot going on around that time. So Mark worked in the policy department. There's a team of ladies working in that team. He changed his mind several times as to how he wanted it done. He asked us to forward all correspondence to the attention of Mark and his team. They would then coordinate the distribution of those submissions to whoever it be in the department and control, yes, that's with Harry Smith or that's with Mary. It was received on this date. So a form of register of submissions received. I think at one stage we had 22 submissions up there.
Right. So is it your understanding that this was an example of Mr Beecroft being responsible for getting your submission to the DWC?
No, Mr Breakoff was just the conduit by which Mick could go to and say, Paul's just rang me, or I've had a call from the regulator asking, where's this submission, who's got it? Rather than go around to everyone and find out who's got it.
Right.
It later changed, probably changed 3 or 4 times, as to who they'll go to. And ultimately you'll see the letters started going to the directors themselves and not always Mick. Mm-hmm. It would often be Mick or the chairman on the more serious matters.
Do you have a recollection of speaking to Mr Beecroft about this particular submission?
No, there was no need to. It was just him and his team were the conduit to which to distribute.
Thank you. Could we please have document CRW 709 109 2277? And this is a...
Yes, I remember this too, yes. So there's an example of the gaming departments had come to me with a number of initiatives. The third one is the chip exchanges we've just been talking about, which had initially, if I recall correctly, not been favourably received by the department. So we would ask them if they'd like to come down so we can walk them through what's planned. I'd ask the relevant department to set up, say, a poker table in this instance, for us to demonstrate how something that we were intending to lodge would operate. So when they did receive that submission, or they may have already received it, I can't recall, they understood the mechanics of it all, what it looked like and so forth.
Right. Well, can you see that it says 2:30 to 3 p.m. to chip exchanges between gaming tables in the same pit? You may recall your department was initially not in favour of this proposal. However, Crown Perth was invited to discuss this matter further with your department.
Yes, I recall this particular matter. The submission, there was a bit of nervousness with respect to some of the officers that were relatively new there. They may not have fully understood the mechanics of how revenue processes work, and it was initially either rejected or stalled or something. So again, through our operations meetings or through my chats with Mick or others, I'd say, look, can we meet and go through this again and walk you through it, just to explain, because there seems to be some confusion about the impact this will have. Again, you're talking some changes to people that have been there long term and or are new, sometimes nervous about agreeing or approving something when they may not fully understand it all.
Do you recall,
quite understandable.
Do you recall that at a DRGL operations meeting in June of 2014 that Mr Connolly said that he would do a review of the decline by the GWC to approve this proposal?
If it's in the minutes, I accept that. Without me seeing the minutes, is it in the minutes, is it?
It is. I'm just trying to find it. I have the wrong number.
And that What date was that? Sorry.
June, I think, 2014.
Okay, so then it took us till September to. Unfortunately, gaming want things, but they don't necessarily get things in order as quick as what they'd like. But yes, I accept that. And that might have been precipitated because we discussed it during the operations meeting. And and it would usually be me, I would talk to Mick about what I felt was the obstacle, and the obstacle may, in this instance, not be fully understood. So he took it upon himself, along with Lance, to come down and have a look at it. Lance, at some point in time, was a relatively new officer, but he was a director in the department.
We'll move on to reduction in gaming table supervision levels. In 2014, you mentioned in your statement that a working group was put together at Crown.
Yes.
And you said it went for about 7 months. Who was chairing that working group?
Lonnie Bossy, CEO of Gaming.
And who else was in the working group apart from yourself?
Myself, Sasha Grist, General Manager Table Games, her 2 offsiders. It was considered highly sensitive because of the potential impact on employment. Believe it or not, we all signed non-disclosure documents. It was that confidential. We had to bring in finance and other departments to obtain information that we felt was necessary in order to put a comprehensive submission to the Commission.
Thank you. If we could go to page 2 of the statement on the screen.
Sorry, just on that, I think Josh certainly popped his head in on a number of the meetings, and ultimately, as I've said there, it went to the Crown Perth Executive, and then I understood, although I don't definitively know, but I think Josh told me it was going to the board.
And what were the merits that were discussed? What was the benefit to Crown from introducing this policy?
Well, certainly there was a cost saving from a labour perspective. If you analysed the error rates and the role of the inspectors and the role that pit bosses were playing, and the benefit achieved from them from what was originally considered important roles, and they still are important, but it was, and plus the business was keen to upgrade its surveillance system, if I recall correctly, and that was a significant capital investment. All of those matters put in the letter were considered important.
We've heard from other witnesses that this policy led to, in their opinion, a decline in operational standards.
Yes. There is an extensive letter on that, on file. There was because if I recall correctly, the Commission insisted increasing surveillance manning levels and reports to be sent through. An internal auditor was appointed full-time and she had already been appointed earlier, to full-time audit gaming activity. So there was an extensive report put together in terms of the quantitative nature of breaches of rules that were occurring before and after, and I'm reasonably confident we demonstrated the fact that because there had been a change in structure, that there wasn't a decline in suspected illegal activity or errors occurring at gaming tables. And when I talk suspected illegal activity, we're talking about the day-to-day punter having a crack at being opportunist at a game, or in fact a dealer, inspector or otherwise being corrupt.
So is it your evidence that you were aware that there is that people hold that view that there had been a decline in operating standards, but it's not your
No. I mean, again, I owe nothing to no one here, but things do change, businesses change, and you can't hold on to what's been that forever. And I didn't see that in the information that I gathered. I met with the internal audit lady that had been for some 3 years doing audits of table games, and she kept statistics of any potential breaches of rules, procedures. I went through all of the, not just me, there was 3 of us actively involved, all of the surveillance reports of errors, the type of games, and it didn't reflect the suspicion that we've just been talking about, a decline.
Thank you. We could go to page 9 of the witness's statement. And under Q27, the second dot point, you're talking about generally, but you use table supervision levels as an example.
Yes.
You say
Yes.
the changes were sought to enable Crown Perth to remain competitive with casinos in other Australian jurisdictions.
Yes.
So would you agree the dominant driver for the change in policy was to maintain or increase revenue at table gaming?
Oh, no doubt. Any business, if its focus is not on ensuring revenues maintained or improved, is a bit negligent. It shouldn't be at the expense of, given the uniqueness of the casino industry, of the integrity of gaming operations. But where there's merits in putting something forward and evidence to support that it hasn't declined, in my opinion, irrespective of what might come out of this commission, because from a day-to-day operation perspective, I'm confident it was fine.
And were you involved in drafting the letter that was sent from Mr Preston and Mr Bossy to the GWC to formally put that proposal up?
Yes, I spent a lot of time on that matter, as did another colleague of mine. There's 2 of us are the principal drafting persons.
Who was the other colleague?
Miss Sasha Grist.
Was there any informal engagement with anyone from the department before you sent that letter?
Because of its confidential nature, there may have been, and I don't really know, discussions with... In fact, there was, as I understand it, there was a meeting with the chairman of the commission, and I understood it was Barry Sargent, Barry Kelstead and Josh, before it went to the department. So Barry Sargent, even before I think any officer within the department, including the chief casino officer, was aware of this proposal. But again, I wasn't privy to those meetings, but I seem to recall that did occur.
Thank you. And did you know, within about 6 months of that change, so
Yes.
in August 2015, the department changed their regulatory approach by removing the inspector presence at the casino?
Was that the timing of it? Was it? I can't recall the
The
timing.
25th of August 2015, that was approved by the GWC.
Right, okay. As I said earlier, it was certainly on the cards in my early days that there would be a shift in the inspectorate's role. It took many years, obviously, to get to that stage, so it's been talked about since 1989 onwards,
And
off and on.
to your knowledge, was that driven by cost?
At the department?
Yes.
I don't know what was driving it.
Thank you. Is that an appropriate time for a short break?
Yes, then we'll just take a 10-minute break, Mr Hume, so you can stretch your legs.
Yes, thank you.
All rise.
Please sit down. Thank you. Thank you, Ms. Nelson.
Thank you, Commissioners. In March 2015, you sent an internal email within Crown in which you described a new self-reporting casino tax portal called Navigate or
Yes.
Sharperlight,
Yes,
that Crown had to report revenue data to the department on a daily
daily basis.
basis
Yes.
and an end-of-month basis.
Yes.
Is it correct to say that that was a self-reporting tax portal for Crown?
No, that was just, well, I don't see it that way. The regulator, unbeknown to us, had chosen to, rather than, I don't know if you've ever seen the packs of revenue data that comes through, it's a bundle of papers like that. Rather than get them, in fact, probably bigger than that, rather than get them in a paper form, it was agreed to lodge the information electronically. That was what the regulator wanted. The regulator had every opportunity to go about doing its normal audit work that it had in the past. It was just their means, as I understood it, of uploading data electronically, no different than you would do your tax return today, as opposed to lodging a manual one from many years ago.
Well, when someone does a tax return today, I would say that was self-reporting because the tax department doesn't go behind the figures that I submit.
Right.
Was it similar
Okay.
for Crown in this instance?
Well, yes, but what the regulator does with it after that, I'm not sure any longer. But they used to have an active role in what I termed a tick and flick exercise in looking at the information.
Behind the reported figures?
No, they used to, when they received the manual paperwork, they used to sit there with the transaction documents and tick them off. Equally, the data that they received for their system anyway was on a disk.
Right.
And that disk would be uploaded to a PC as opposed to a central repository that they now have.
Mr Hume, are you saying they still receive the same information, all of the same information that used to receive
My
in paper?
understanding, yes. They may not get the actual what's termed master game report, but that's available. This is the one that Sandy did call me about, saying don't send that to us anymore. If we need it, we'll come down and grab it from you. So income control would keep the unaudited and audited master game reports, where we ordinarily you'd send them to the government inspectorate along with the daily revenue figures.
Did they need the master game report in order to do that tick and flick process that you've just described?
Potentially, yes. It's been that long since, must be 12, 14 years since I've done it, so I can't remember the exact process we used to follow. But having come from a former accounting background, I used to question sometimes what we're actually doing from a tick and flick exercise.
That is when you're at the department?
Yes. But as I understood it, the Chief Casino Officer still required his officers, or the Commission's officers, to do audits on revenue. I've actually queried it with income control on a number of occasions. Has government inspectors been down to check anything, and they hadn't done that.
Thank you.
Thank you. Could I have document CRW.709.003.0904? And if we could go to 0908, so this is an email chain, we're just going to the back of the chain.
Oh, yes. So what happened there is those people in that email, and potentially others I can't recall now, maybe a couple of people from income control, we went down to the DRGL's office. They had the IT people that they'd engaged to develop this portal, and they walked it through with all of the users, if you like, from the finance department, and explaining how it all operate. Obviously, we had a number of queries about it.
I see. Now, if you read the second paragraph in the middle of the page, starting I really don't think, you can just read that to yourself.
Right, okay, yep.
Do you still maintain what you told Commissioner Jenkins, that the department was receiving the same information through this portal that they would have been manually before?
Yes, they weren't receiving all the same documents, but the actual details of the revenue was the same, but the other pack of documents and supporting documents they didn't receive. Sorry if I've misled you there.
So they were receiving the revenue numbers, but not
The
necessarily
supporting paperwork.
the primary source documents from which those numbers were attained. Is that correct?
Yes.
Thank you. That can be taken down.
Sorry about that.
Did you have any knowledge about how casino taxable revenue was calculated by Crown?
By Crown?
Yes.
I'm familiar with the formulas used, yes.
And is it true to say simply that it's calculated by adding Crown's takings from gamings through the EGMs, the table games, junkets and high roller gaming, and then deducting what Crown has paid out as winnings from gaming?
Yes, and there's an element of, it's called what in and what out, and I can't remember that componentry off the top of my head. It's to do with ticketing, if I recall. But the formula for gaming machines is in the manual, and I had intended, although I explained it to the officer before I left, and I explained it to as many people as I could within the casino, how table games revenue is calculated.
To your knowledge, when Crown was calculating the winnings deduction figure, did they include the cost of any accommodation, meals, drinks,
Not that I know of, no. And
or tickets given to patrons,
tickets?
or any tickets to events?
Oh, no. It was raised.
When was it raised?
Had been raised for 4 or 5 years maybe I could explain, on gaming machines, a patron can win a prize as opposed to money, and a prize could consist of a motorbike, a stereo system, or anything like that. The Commission approved the use of these types of bonus prizes, but Crown must say the car's worth $50,000 advertised price, but if the car was purchased for $45,000, they were only permitted to deduct the $45,000 from tax, not the recommended retail. There was a discussion regarding allowing gifts such as free hotel room, like a hotel room and other bits. That was raised with the Commission, with the officers from the department in an operations meeting.
Who raised that?
Lonnie Bossy.
When did he raise that?
It had been raised a number of times over a number of years, probably 16, 17, I think, if I recall, 18. Quite rightly, Mick said, look, I don't mind if you want to utilise giving away prize relevant from Crown, but it can only be at its cost. In other words, just because you're selling a hotel room for $400, if it costs you $100 to operate it, that's the only amount you could deduct. Now, that never, to my knowledge, progressed any further at Crown, Perth.
So it was raised at an operations
Yes, probably
meeting
a number of times.
a number of times
Yes.
by Mr Bossy on
Yes.
every occasion
Yes,
during 2016-17, or
Yes,
also outside that period?
I can't remember exactly, but it has been raised.
And Mr Connolly said, I don't mind.
Well, he said we'd obviously need to incorporate it. There's things you've got to consider. It's got to be included in the rules, provision in the rules, or within the accounting manual, because the accounting manual describes some of the prizes that we talked about, such as motorbikes and non-cash prizes. But it would have to also be approved by the Commission. But we would also, Crown, have to demonstrate and that it was only cost that because that's a means of which you can deviate your revenue that way.
And when you say prizes, are you talking about the cost of prizes attached to a gaming event, or are you talking
Yeah.
about loyalty?
Through
Gratuities.
a gaming event. So it could be prizes for weekend stay, weekend plus meals as your prize instead of a stereo or a car.
And how would a patron get one of those prizes,
Oh,
like a weekend
The
stay?
way the electronic gaming machines operate, and depending on which type of jackpot you're talking, I'll give you a simple example. Win this car. There's a car on display. On each standalone electronic gaming machine, there is a meter. The meter can go between $1 and $10,000. I'm just making this up as to try and describe it to you. Somewhere along the line, there's a random number generator determined that at $6,629.29, you're going to win that prize.
Okay.
So you're not winning the $6,629, you're winning the prize that's on display. It's called Win This Car.
And on each occasion that Mr. Bossy raised this during 2016-17,
Yes.
did Mr. Connolly give the same response?
Oh yes, every time, as I would expect from Mick, and that's what I would do. You can't. It can only be cost.
Thank you. And you've talked about the ticket in, ticket out proposal, which was introduced in 2012.
Sorry, can I go back a little bit?
Yes.
There wasn't talk about prizes such as, did you say parking?
No, I didn't say parking, I said accommodation, but
Yeah, there was accommodation.
what about parking?
That wasn't raised. It was only food and beverage packages and hotel accommodations, that type of.
Did patrons get given accommodation and food and beverages just because they're a Crown Rewards members?
Yes, yeah, they were able to redeem, like any rewards frequent flyer, if you're a frequent flyer. You get so many points, you can redeem it for whatever goods and services to the value of those. There's a whole formula associated with points, which the marketing and analytical team deal with.
And they'd earn points from gaming turnover?
Could be points from any activity at Crown. So you might be going to the theatre, a hotel, regular hotel stayer, food and beverage, and gaming.
And if they redeemed items such as accommodation or meals and beverages
Yes.
from those points,
Yes.
were they then included by Crown in their calculation of
No,
winnings?
not that I've never been aware of that. And I'd have people within the department's finance would raise it with me if that started happening. I've never known that to occur.
How can you be sure they'd raise it with you?
I had a very close working relationship with the finance and the gaming product manager. I'd like to think I could trust them implicitly. They would come to me with various things, and if necessary, I'd raise it. And they never did.
And did the Legal Compliance Committee ever action any review of internal processes to make sure that wasn't happening at Crown?
No, not that I know of. I wasn't involved in it. I don't recall hearing of any review.
Now we're moving on
I think
to...
it became all too hard to start quantifying what the cost of a meal is, or a meal in a hotel room.
So is it your evidence that there was some discussion about
Yes.
including that in winnings?
Offsetting the cost of those against winnings,
Right.
because they were being issued as a prize for the conduct of gaming.
But if it's issued as not a prize from gaming but redeemed from your Crown Rewards loyalty
Crown
points.
Rewards loyalty program had nothing to do with revenue.
Thank you. Now moving on to ticket in, ticket out.
Yes.
Which was one of the corrections to your statement that you made this morning. You told Commissioner Jenkins that there was a proposed introduction of TITO driven by Crown Perth executives and it was discussed and tested before all departments, before it went to the GWC, as I understood your evidence this
Yes,
morning. Is that
yes.
correct?
Yep. Whether it been flagged with the Commission earlier as an initiative, I can't recall, but ultimately it went to the Commission as a formal approval and submission.
And you also alluded in other evidence that there was a demonstration given to the GWC of the system, or to department members?
Department officers.
Oh,
Yeah.
department officers. And who was at that demonstration?
Oh, I couldn't recall, sorry.
Was Mr. Connolly?
I can't recall. I had so many different officers coming to different demonstrations.
Did you travel over to Melbourne with Mr. Connolly or Mr. Sargent in relation to getting that TITO
I've
system
never been
approved?
to Melbourne other than a private holiday with my wife.
Do you recall if there was any discussion about mitigating potential harm from bringing in that ticket in, ticket out system in terms of responsible gaming?
Look, I'm sure that would have been considered. I do notice you sent me an email from Michael Egan and he sent it to me in confidence. I can't remember that document, to be honest with you. He did send it to me in confidence. I've got no doubt, knowing Michael, he would have taken that up with a CEO of gaming. He's a champion, and he was the champion of the setting up the compliance committee and the RSG initiative at Crown Perth before any legislation. But he would have definitely, I'm very confident saying he would have taken that up.
Thank you. Were you involved in any approval processes for new EGMs being introduced onto the floor?
The only involvement I had was invariably James Sullivan would ask me if I could facilitate a meeting with officers of the department. And that could be, in the end, it was mainly the relevant directors and managers. Mick would very rarely turn up because he didn't have time. James would do a PowerPoint presentation to them. That same PowerPoint presentation would be that put before the Commission. So the idea was to show them, to inform them as what we're looking at, to seek their input. Is there anything there that stands out that might be of concern to you or officers or the requirements? Beyond that, all electronic gaming submissions were made by James.
Thank you. Do you recall a Crown proposal in June 2016 to put a play-through agent proposal before the GWC?
What's
So,
a referral agent program?
So international patrons being able to phone in through an agent.
Oh yes. I was. Josh came to see Claude, and Josh came to see me. Between Claude and I, but principally Claude, that submission was drafted to the Commission, and we did look at. Was it bookmakers? The Commission had enabled bookmakers to allow telephone betting to occur as part of our review, and we were asked to put that before the Commission.
Was there any discussion by Mr. Preston as to what the motivation was?
As I understood it, my recollection is it was happening in other casinos, and I think Philippines might have been mentioned. The business had a desire to implement that initiative.
Was there any discussion between you, Mr. Murray, and Mr. Preston about the AML risks through that proposal?
Yes, I think we did discuss it, and I even went to see the lady that works for me, who was the AML officer, and she was a little bit disturbed, saying we're going to have to do proper due diligence, third-party checking. She rattled it all off what they ordinarily do. So that was, if it was approved, that was certainly something that would need to be considered before being implemented.
Did you have any informal discussions with Mr. Connolly about this proposal?
Other than when he got it, I think he may have rang us and said, "What's this?" Because he wasn't particularly supportive of it. But once again, Mick always said, it's not for me, it's up for the Commission to make the determination.
Could I have the witness's statement at page 9, thank you, WIT.0010.0001.0009 at page 0009.
Sorry, which one am I looking at?
Page 9.
Yes.
The first dot point, you're talking about Crown Perth having access to a broader range of EGMs as opposed to having them purposefully and manufactured and designed.
Oh, yes. Okay, sorry. Wrong. Question 20, or topic
Yes,
27.
Q27, thank
Dot
you.
point number 1. To improve Crown Perth access. Yes.
What was your understanding of why they had to be manufactured and designed purposefully?
The Bursard Island Agreement prohibits the use of poker machines in Western Australia. I think Crown Perth and possibly Darwin, and I could stand corrected, are the only jurisdictions which needed to get machines purposely manufactured to suit Western Australian WA appendix standards, and whereas other jurisdictions where the national standards were used and there was a broader range of products available, as I was advised, could mean that there was more readily access to products as opposed to we had to wait a long time. I remember we sought in principle approval of some games and it took a year or two to get developed.
So,
But again, that's an area that James Sullivan managed.
and how was Crown proposing to get access to a broader range of EGMs?
By having the WA appendix amended and the changes, and it gets a bit technical, which I have now forgotten about, I had to get my head around it, to do with those particular standards within the appendix, the WA appendix, enabled the manufacturers to have machines readily available for us.
And if you change the WA appendix, would you change it so that it was more in line with what was available in other states in terms of EGMs?
I think there's 10 criteria which the Commission's determined to identify those which are electronic game machines in Perth and not spinning reel machines. We went about seeking the technical advice of an accredited testing facility, because they are the so-called experts in testing these. They've got mathematicians and IT specialists to tell us whether those changes to those particular WA appendix would, I don't know how to put this, but result in them actually being pseudo poker machines. But I'd have to refresh my memory on the exact wording of what they said.
Thank you. I'll take you to an Operations Division meeting in March 2014, which is DLG 0004 0001 0236.
Yes.
And we can see that you're in attendance
Yes.
on the 27th of March 2014.
Mm.
And if we go to item 4.1 on the second page, the very last paragraph,
Yes.
DDG further advised that the DWC required the DRGL to examine the current 5-second speed of play provisions detailed in the EGM National Standards WA Appendix and provide a report on whether this speed of play should be increased to 6 seconds.
Right. Okay. I do vaguely remember this.
Do you recall that Mr. Connolly asked you personally to ensure that he got some high-level dot points explaining the impact of the change in the speed of play on Crown Perth?
He may have, but I don't recall it specifically.
And going from 5 seconds to 6 seconds, would that have a negative impact on Crown Perth or a positive impact?
Oh, I would suggest that it would be a decline in revenue. Depending depending on which way you look at it from an RSG perspective, it could be an improvement.
Thank you. Could I have CRW.709.139.8384? This is an email from you, the 17th of June 2014, to Lonnie Bossy and Joshua Preston.
Yes.
I'll just let you read what's on the screen.
Yes.
Does that jog your memory?
It does. Yes.
And do you recall whether Mr. Preston or Mr. Bossy did do that?
I don't actually. I wouldn't be surprised, and my recollection seems to be there might have been a meeting called with the product manager and the general manager of e-gaming, along with those two executives and myself. I actually can't even remember what happened with this, but
Well, ultimately, in June 2014, you were advised in an operations meeting by Mr. Connolly that the matter had been discussed at a GWC meeting
yes,
late in June, and GWC had resolved not to change the speed of play.
right, okay.
Now, taking you from 2014 to 2018, in May 2018, do you recall discussing with Mr. Sullivan and Mr. Murray some possible changes again to the parameters for electronic gaming machines?
Yes, I know James had been, and or Lonnie, and potentially Barry at one stage, Barry Felsted, had probably over quite a number of years muted the idea of getting changes to the WA appendix. Whatever form that might be, there was never any real direction. I think speed of play was certainly on their agenda. And there'd been a number of discussions that Lonnie had met with me, Claude, James and Josh, if I recall correctly, and another fellow, the general manager of gaming machines, with a view of putting something together to the commission. And that had been off and on for some time now, resulting in James, Sullivan, Claude and I picking up the ball, and because they kept in and out, wanting it done, not wanting it done, wanting it. So we just grabbed it, put it together as a submission and sent it to them and said, is this what you're wanting?
And do you recall in the last year at Crown in 2019 that you were successful in getting the speed of play?
I think it came through just before I retired. I can't remember.
And in order to get that,
There was lots of playing with the words to do with the WA appendix, if I recall correctly.
and did you have several meetings with Mr. Connolly to discuss the proposal
Yes.
during 2019?
Yes, and I think it was even raised at an DRGL operations meeting, if I recall correctly. This topic had been discussed for a long time.
Do you recall Mr. Murray helping to draft a paper for Mr. Connolly to put before the GWC in July 2019?
Vaguely, but I'm not specifically clear.
I'll show you a document,
Yes.
DLG.8.001.0003.3735. This is from the 18th of July 2019.
Sorry, Chief, thank you. Yeah, what was happening is as I had made it clear my intended retirement, and it didn't look like they were going to appoint anyone, the work was going to be shared. Claude started getting more involved in my side of the work over the last year. That's my, which is fine, but
You can see the attachments
is
listed.
that the letter to seek the amendment to the WA appendix? And because this is the to and fro wording, we were trying to work with the gaming product team, and I think James was working with some manufacturers to make sure the wording is exactly right as to how they wanted it. But I can't remember this specifically.
It does attach a letter to GWC of the
Yes.
19th of March.
Yes, I saw that.
2007.
There's two letters there, isn't there?
Yes. And also your one from 2018 that you gave evidence about a few minutes ago.
Right, okay. It wasn't unusual for the regulator, if we wanted to change, say, the Burswood Casino directions, that we were asked if we could put a draft to the changes of the directions, which historically were prepared by Parliamentary Council on behalf of the Commission. But Parliamentary Council, at some stage, as I understood it, felt they didn't want to do that type of work. So the officers within the department were endeavouring to do that. So we were, at some stages, depending on who I was dealing with, were asked to put an amendment, draft amendment within the directions. So this might be one of those circumstances.
Right. Thank you. That can be taken down. Moving to another topic. In your statement, you referred to select patrons conducting transactions at the hotel service desk.
Ah, yes,
So as to source funds for gaming purposes within the casino.
yes,
And that's at your witness statement at page 7.
yes. I've got it here, so you don't need to.
Can you explain a bit more about how that process worked and when
Look,
it was in place?
It was in the manual before I returned with it to the department and or the working for Crown that I recall. I can't remember the specific mechanics around it, but I know a staff member, I seem to recall, had to accompany the person to the hotel, get a receipt, and then take the receipt to the cage to conduct the transaction. Now, the basis and why it was all put in place, I don't recall being involved in it at any stage. And I could stand corrected, I'm not sure how long it's been there.
So it was in the manual when you returned to the department in 2007?
That's my recollection.
2006, sorry.
Yes.
And did it stay in the manual when you moved over to Crown?
Yeah, yes, it would have been there for some time, yes. And I think there was some amendments made to that section as part of the review when the manuals were being put into the new format.
And that review was being undertaken by yourself, wasn't it?
No. I left it to my colleague, Denise, because I was just too busy. And often I'd come in on different matters when there wasn't agreement on matters, to work with the operational department. So they would draft their procedures, send them to us, and we'd review them to say, hang on, that's not worded well, hang on, that's not right, you missed this. So it depends on who we're dealing with.
Okay, so you recall that it was in the manual.
Yes.
Was it a practice that was happening at the time you were at Crown?
I don't know how, that's again a question for maybe Mr. David Brown. I don't know how frequent or if they used it. There was often things that were put in and didn't get used. There's one that you've given me to do with chips from being put in a cupboard within the international room. They wanted it approved. I got it approved, and about 9 months later, they still hadn't implemented it or weren't using it. So it depends on whether they were using it. I don't know.
Thank you. We move on to, I want to ask you about cheque cashing facilities.
Yes.
Did you have any understanding of how a domestic patron who had a cheque cashing facility application approved
Yes,
for a certain limit,
yes.
how that patron could get that limit extended during the course of their gaming?
There's we're talking about somebody presenting a cheque now, aren't we?
Well, what do you understand it to be?
Okay. There is...
If you don't know, please say you don't know.
Yeah, okay. Look, I'd rather not go on because I may be confusing myself and you, but there is something within the Burswood Casino directions about the receipt of cheques and the consolidation of those cheques.
Did you have any visibility over how often that facility was used by patrons or how it was used?
That was all managed by the cage.
Thank you. Were you aware when you're at Crown that Crown maintains staff in Malaysia to engage with Crown customers over there?
I understood they had a number of offices overseas. I think there were some 67 of them at different countries. And the reason I became aware of that, at one stage those persons were required to be licensed. Then because of the difficulty in getting police clearance certificates, they weren't licensed by the Commission. Then for some reason that got reverted. And so there was 67 people I had to, through my PA, ensure we had position descriptions and get them all licensed.
And some of those people were in Malaysia?
At various countries around the world, yes.
And in terms of those people in Malaysia, can you give the commissioners a time period that that Crown had staff working over there?
No, I don't. I couldn't tell you. I had no involvement in that side of the business. Well, I can potentially say it was about 2015, 16 that we got all them relicensed. But again, all that information's on a file at Crown Perth.
So your only involvement in the Malaysian office was getting the employees licensed?
That's correct. I don't ordinarily do that. That's something that's managed by HR and payroll, but I was asked by Josh if I could help get these people licensed.
Nothing further, thank you.
Thank you, Ms Nelson. Are there any applications?
Yes, Commissioner.
Mr Garris.
Thank you. Mr. Hume, my surname is Garris and I appear for the Crown Company, so I just have a few questions for you. I have document CRW.709.132.6189. Now, Mr. Hume, Ms. Nelson took you to this document.
Yes.
And relates to the request to amend the manual. You indicated during your evidence that this was essentially prompted by a discussion that Mr. Connolly had with you at his suggestion. Can I just direct your attention to the opening paragraph where you refer to a discussion?
Yes.
I should say Mr. Preston, who's the author of this letter, refers to a discussion between you and, of course, the addressee of this letter is Mr. Connolly.
I'm just having difficulty hearing you. Sorry.
You can see that in the opening paragraph.
Yes.
There's a reference to a discussion between yourself
Yes.
and the addressee, which is Mr. Connolly, and
Yes.
that discussion occurred on 9 February 2017.
Yes.
Is that the discussion that you're referring to in which Mr. Connolly suggested the amendments to the manual?
That's my recollection, yes.
Thank you. Operator, can I then have another document brought up? It's CRW.513.024.6387. Commissioners, just for the purposes of the record, this is a more complete version of one of the documents that Ms. Nelson took Mr. Hume to, which was GWC.0001.0007.0357. Now, Mr. Hume, Ms. Nelson directed your attention to numbered paragraph 2 of this letter, and suggested to you that the addressee of this letter, Miss Perry, may have gained the impression, based on the content of paragraph 2, that the accounts that had not been provided to the Commission was confined to just the month of July 2019. Do you recall that discussion with Ms Nelson?
Yes.
Now, during the course of your evidence, you explained that the opening parts of this letter were quite standard and that it was the balance of the letter that really addressed the omission.
That's correct.
I just want to take your attention to the second last paragraph on this page, which first of all refers to the fact of a discussion between yourself and Ms Perry, and goes on to identify the inadvertent failure to provide the bank reconciliation statements, and that those were then provided over the period 1 July 2018 to 30 June 2019. And the letter goes on to then state that although not a requirement, the actual bank statements were then provided for each of the bank accounts for that same 12-month period.
That's right.
Does that accord with your recollection of the discussion that you had with Ms Perry at the time?
Yes.
And can I just, operator, have you move forward to page 6444? And you'll see, just while we're moving across to that, it's there's a reference to attachment 5 at the end of that paragraph, Mr Hume, the paragraph I just direct your attention to. Can we go to page 6444, please?
I do apologise. I'm having difficulty hearing you.
I'll speak up.
Thank you.
Mr Hume, thank you.
Okay.
Just while we're here, I might ask the operator if we can just keep this information retained to the private screens. There may be some non-publication issues in relation to it. Thank you. Mr Hume, we'll just bring up the document on the screen in front of you.
Yes, thank you.
And if we could just move that page up slightly, you'll see on the right-hand side the reference to it being attachment 5.
Yes.
So does this assist in your recollection to show that?
Sorry, just while on that page,
Yes.
are they all the relevant accounts that we sent, just to remind me?
This is just the cover page to attachment 5, and I'll take
Right,
you to some
okay.
other pages. But you'll see that there is a listing here which includes, at the bottom half, references to the Riverbank Investments account with
Yes.
CBA. And there's also 4 different currencies in relation to that: Australian
Yes.
dollars, Hong Kong, Singapore and US. Then can I ask the operator to move forward to page 6695. So I'm just going to take you to a few instances within this bundle of documents which shows the material that was actually provided to the Commission or the Department.
It was quite a bundle of documents, if
Yes.
I recall. And that may be why we only just gave them the 12-month period, thinking, gee, they're going to get swamped with all of this.
So pause there, thank you. So you'll see this at page 6695. This is one of the first statements.
Can you just make
This
the-
covers the
big-
period of July 2018.
Yes.
And it relates to Riverbank Investments, and this is the Australian currency
Yes.
account, correct? Then can we skip forward, please, to page 6731. Now, I won't take you to all of them, Mr Hume, but there are obviously similar statements that cover that entire 12-month period.
Yes, yes.
At 6731. Now, this is June 2019, again the Australian currency account. Can we just go forward please to 6736? Now this is the equivalent information in relation to the Hong Kong currency account, is that correct?
Yes, it looks it.
And this is in relation to July 2018.
Yes.
And I can tell you, I won't ask the operator to take you to it, that there are similar statements covering the period up to June 2019. There are also similar statements for the 12 months relating to the Singapore dollar currency and also the US dollar currency. So does that accord with your recollection in terms of the information that was provided to the department?
Yes, I mean, seeing that, yes, it
Thank
does.
you. Now, you may recall that in the covering letter, there was a closing statement to the effect that if the department required earlier information, that they should contact yourselves.
Yes.
To the best of your recollection, did the department ever seek or request that earlier information?
No, they never contacted me. That doesn't preclude them going to the finance department, who may have or who do ordinarily send this information, but they would ordinarily contact me because they knew how important this was. Ishak in particular, he would have been their contact point because he's the one that often dealt with them. No, to answer your question, I don't recall ever receiving any additional information being sought by the Commission.
Thank you, Mr. Hume. Commissioners, no further questions.
Thank you, Mr. Garris. Any other applications, Mr. Sadler?
Thank you, Commissioners. Mr. Hume, my name is Sadler and I appear for the Gaming and Wagering Commission. Just a few questions on the same topic.
Yes.
Discussed before. So, you gave evidence before lunch about these bank statements and your interactions with them. I just want to test the timeline slightly with that. So, is it correct that you first became aware of these accounts being provided from the casino to the Gaming and Wagering Commission when you had your role as the Senior Regulatory Officer in 1994 to 1998?
Sorry, could you just repeat that?
When you first became aware of the provision by the casino to the... That might help.
Thanks.
First became aware of the provision of these accounts by the casino to the Gaming Wagering Commission.
Yes.
Just to get the timeline right on that, was that when you're in the role of...
When I was the Senior Regulatory Officer, I recall them coming in.
Yep, 1994.
Having said that, I remember the pack coming through the office of the Inspectorate.
Yeah.
And that would come through the Inspectorate and go straight to head office.
Okay. And you outlined a couple of roles you had when you were the Senior Regulatory Officer. There was two. One of them was to develop this risk-based program,
Yes.
this audit program. And it's correct that one of the aspects of that was revenue control, I believe.
The revenue side, the revenue collection. There's lots of controls that lead to revenue. It's just not the account process, but yes.
What I'm trying to establish is where you came across these accounts. Was it in the purposes of the audit, or was it in your role, your job as assisting the chief casino operator? In what context did you come across these accounts and the letters?
The bank accounts?
Yes.
Oh, as the Senior Regulatory Officer?
Yes.
That pack of documents would come into the office and just land on my desk or one of the fellows working for me. But I was familiar with the paperwork that would ordinarily be sent from the casino operator, having been a government inspector in earlier years.
And appreciate this is a very long time ago.
Yes, that's right.
But you don't remember who sent those documents to you and what accounts were in the pack?
Oh, no. I know who used to send them.
Who was that?
As in...
At the casino?
It was a fellow that occupied Ishak's role. I can visualise his face, sorry.
Occupied whose role?
Ishak Tan, his name is. He's the fellow that's been there for 32 years now.
And what role is he in?
He's in the finance department. I think it's income control.
At the casino?
Yes.
Yep. Okay. You again came across these letters and these accounts being provided to you in the 10 months when you resumed your role at the department as the senior casino inspector. Is that correct?
I didn't ordinarily see them at that stage. They used to go to another fellow in the department.
And who was that? Do you remember?
His name was Peter.
Actually, I remember you raising this and you couldn't remember his last name.
I can see his face, but sorry.
And was it at this point that you asked, that you noted that multiple accounts were coming in?
No.
I believe, and I could have this wrong because I have the transcript, your evidence was before lunch that you had a conversation with Mick Connolly about seeing that there were 2 accounts.
Oh, sorry, you're referring. Okay, maybe I'm misunderstanding the question. Having started at the department, I was aware that I was refreshing myself with the Burswood Casino directions.
Yes.
And within the directions, I think it's direction 5 or thereabouts, it talks about the casino operating a casino wagering account.
Mm-hmm.
At the same time, whilst reading the casino manual operations, or accounting manual as it was known then, I noticed within the manual it enabled the use of a number of accounts. And I sometimes try to be a bit of a stickler. The directions say a wagering account, and now we've got multiple accounts. And yes, that's how I raised it with him.
And when you raised it with him, was that when you came back in 2006? Or was this back?
September, October, November, December, sometime like that.
Okay. And when you looked at the accounts at that stage, do you remember who had sent the accounts to you?
Well, the only accounts I saw were those, if you look, if somebody's got the casino manual back then, it actually has a whole section, says there may be casino accounts operated by Crown Resorts, Crown Limited, Burswood Limited, or any other Crown-related companies, or words to that effect.
The question wasn't spurred by the fact you'd seen that letter come in. It was by looking at the manual and looking at the directions.
Yes, that's correct.
Thank you very much. Just for the purpose, for the benefit of the Commission, can you explain the difference between the revenue pack that comes in and then the accounts that are attached to the monthly letters that are provided by the casino?
I haven't seen them for a long time, but the revenue packs, there's a daily pack that goes to the inspector, used to.
Yep.
We're talking historical.
Yes.
That would consist of, firstly, the unaudited master game report, which would be sourced from the count room.
Yes.
Following income control having done its review, they would forward through the audited master game report, so those 2 documents would be kept.
Yes.
And within the count room, in particular those relevant to table games, there was lots of documentation.
Yes.
They would be kept by the government inspectorate, so there'd be check credits, opening closes, inventories, credits, fill documents, all to do with the movement of chips. So those were retained and kept by the inspectors. At the end of every month, income control would collate all of that information, bearing in mind that the government inspectorate would enter that data onto a spreadsheet, or over time use a disk that was supplied by the casino operator.
It's before Sharperlight.
Yes. And they would say, righto, on the 1st of January, we said there's $10 million being made, you've got $11 million.
Okay.
So there's a form of reconciliation. So invariably, the inspectorate would raise any variations with income control before casino tax is paid to the state.
Okay. And did that, the daily revenue packs or even the monthly revenue packs, did they involve the unredeemed chip count?
Yes.
Sheet? Is that an important component of that?
Yeah, the control of chips are considered important because you may get counterfeit chips introduced into the casino. Mm-hmm. Equally, the casino operator is obligated to pay tax on any unredeemed chips. Because that's a sum received, and they've issued a chip out for that sum received, but no one's redeemed that chip.
And we're aware that the an allocation of, a summary of the unredeemed chips also accompanied the monthly letters.
Yes, I believe it did. My recollection is.
Thank you. So, when you joined Crown in 2007, did you conduct an audit of Crown's compliance with the GWC's directions?
Did I conduct an audit of
the Crown's compliance with the Gaming and Wagering Commission's directions?
No,
A stickler?
no, I didn't conduct an audit of it, no. So in other words, going around the casino just to make sure that they're doing their supervision levels correctly and all that type of thing, no, I didn't.
That's right. And you covered this earlier, but just to confirm, when you joined the Crown Casino, you didn't take over drafting those monthly letters to the Gaming and Wagering Commission?
I've never, what I did do, because some of the quality of the letters were so poorly written, within the cage, income control and others, I helped draft them into a more professional manner, in my respectful opinion, and quoting, as you see there, the relevant direction or section of the Act, that's 4.1a or whatever it be,
Okay.
just to formalise things.
Could we bring up GWC 001 007 0212? For your benefit, this is the first of these monthly records that we have in the online hearing bundle, basically in evidence. And you'll see it's to...
Yes, foreign currency chip program, yes, yes,
and signed off by Craig Spence.
yes, he was the financial controller at the time.
Thank you. The Commission's heard evidence that prior to Mr. Spence signing the letter, and Mr. Alan McGregor signed the letters.
That's correct.
Do you know that to be right?
Yeah.
And what was Mr. Gregor's role?
Alan, again, couldn't tell you what his formal title is, but my recollection is he was the Chief Financial Officer before moving to Crown, Melbourne.
This is the first letter we have, and you'll see. I just want you to have a look at.
Yes.
And ask you a question about this. Just want to have a look
Yep.
at the front cover there. Could I show, just for comparison's sake, can you bring up GWC 001 007 0231? And just note the date on that, so it's a few months later.
Yes,
And then, so that letter is dated 7 July 2014.
Yes.
And next to the 7 July 2014, can we please bring up GWC 001 007 02, 0235. 0235.
okay.
Yes.
That's potentially where I tried to more formalise the letter that being sent to the Commission.
So that was my question. Did you have a hand in
Yes.
changing the front cover of this note?
Yes, I do. I do recall that. I don't remember whether Josh came to see me and talked to me about this, and I said, Josh, because as I said, there was lots of letters going to the regulator which were quite informally addressed and or, I hate to say this, not very well written. So where I had an opportunity, I tried to improve that.
And you see Josh, Mr. Preston is now...
Yes, sorry,
signing
Josh
letters.
Preston.
Do you know why he took over signing the letters from Mr. Spence?
Mr. Spence left. My recollection, he left. Mr. Alan McGregor, being based in Melbourne, formally I don't know why he chose to sign the letter, but he did. I think principally because he worked very closely with Barry Felstead. Barry was also simultaneously signing the revenue. There's a requirement in the directions for the CEO to sign the revenue documents. So Barry would sign those, and Josh took it upon himself to sign these documents for reasons I couldn't explain.
Okay. If we just bring a look at GWC 001 007 0235 being the 15 August 2014 letter, and you go to, and we'll take you to underscore 0062 of that letter. So this is one of the Riverbank accounts,
Right.
and you'll see it's noted in Hong Kong dollars.
Yes.
At the stage of redrafting the front cover of this letter, would you have had a look at the contents of the letter,
Oh,
its attachments?
these attachments? No, I just wanted to. I mean, the direction is simple in itself. It requires casino, was it said casino wagering accounts? But no, I wouldn't have been shown these documents. I don't recall being shown these documents.
So you would have just seen the draft cover letter, to your best
Yes.
recollection.
Yeah, that's going on my recollection. So are you saying to me that those were included back then?
Yes.
Oh, were they?
Yes.
Okay. Well, that's positive because we couldn't get a definitive answer from the finance people.
So maybe I should check your question. What are you asking was included back then?
So are you saying, I think, that included in the
Yes,
letter
yes.
was all the statements relevant to Riverbank?
Yes, well, one question I had that you might not be able to answer is it's only the Hong Kong dollar accounts.
Oh, okay.
Do you know why that's the case?
Can't shed any light on that. Sorry.
So can we go back to the former document, sorry,
Yes.
the report? Reporting letter?
At the front cover of that.
That only refers to the ANZ
Yes, I know that.
accounts, not a CBA account.
Just if you go to, I think I took you to _64, but if you go to _62 on that, I think it's the ANZ account or vice.
Oh, that's a Commonwealth account.
Perhaps _64.
Sorry, can I ask a question? Are you saying to me that that was the letter, but attached to that letter was those bank statements? Right, okay. Well, I couldn't even get that information from... Right, okay.
Sorry, I'm still a bit confused, Mr Sadler. Because, so the document you showed Mr Hume of the CBA account,
Yes. These are the attachments to that letter. It has both for clarification, it has both an ANZ account and a CBA account attached to the back of it, both seemingly in Hong Kong dollars.
I'll take your word for it, Mr Sadler.
Oh, don't take my word. That's just the document up on the screen. Okay, can I bring up, please, GWC...
I'm pleased to hear that, I have to say.
GWC 001.007.0250. And can we put next to that GWC 001.007.0251?
Hang on, sorry, just on that letter, and I don't know if it's on the previous, it says, and other bank statements relating to foreign currency activity. Did that previous letter say that too? Because that's what we're talking about, aren't we? So, sorry,
Just
I'm
asking
asking
one
the
quick
question.
question about this, and I can take you back to the other letter. So, see how the addressee has changed from Mr. Scrow to Ms. Perry?
Yes.
Would that have been your drafting again then on these letters?
It may have been. But having said that, I had, because the directors and people's titles and positions kept changing, I kept sending emails out to the business saying, apologies, Mr. Scrow's titles now is this. He's no longer doing that job, he's doing Ms. Perry's job. So I was endeavouring to try and keep the business units alert to the ongoing changes amongst positions, so correct correspondence could be directed to the right individual in the department. So whether I did it or finance, I'm not sure. Because I remember during that period, I must have swapped about 6 times in 4 months.
Did you want to go back and have a look at the last letter?
Yeah, I'm just, sorry, can I, because on these letters, it talks to other statements relating to foreign currency activity and the previous document.
Yes. So if we leave up, then GWC 001.007.0250 and put that against GWC 001.007.0235.
Oh, there you go. It does say other bank statements relevant to foreign currency activity.
So that's the foreign currency, not Australian currency.
Yes, but it seems, am I right, that they included some of the Riverbank accounts, but maybe not all.
The
From what?
Hong Kong dollar ones.
Yeah. Okay.
Commissioners, can I suggest that we perhaps look at attachment 3A as well as 3B?
I don't know what page 3A is at.
What's attachment
3A, 3B to this letter.
of which letter?
To 0235.
2235. So I think you want to bring up, there's the pages we had up before, my learned friend. It's page 62 and 64. The attachments that we looked at previously.
It makes no mention of Commonwealth Bank, does it? Okay.
I won't have the, what do you have to
3A.
3A.
So this is the Hong Kong.
We'll have, the operator will have to flick for that. I don't have the page reference. It'll be up from 62. So this is the main casino account.
Yeah.
I have no further questions about this document. This,
So do I understand this then, where we've reached, perhaps, that attachment 3A is an Australian dollar account and it's ANZ. The ANZ Bank,
Yes.
and it's Crown Perth, not Riverbank.
that's correct. But I could not say it definitively for every letter because there's
No,
83 letters.
we can only go with what we have. Attachment 3B had two statements. Both, one of them was a CBA statement and one of them was an ANZ statement. And the covering letter simply doesn't refer to, by name, the CBA accounts, but it does refer by name to ANZ accounts. Is that where we've landed on this document?
On this document, I have to go back to the front cover just to confirm they don't talk about ANZ and CBA. But the point I was drawing out then was that it's a Hong Kong dollar account, and we haven't found a Australian dollar Riverbank account until the next document I'm about to take the witness to, which is the document in 20 August 2019, and that's when that includes the paragraph that the witness was taken to a while back, where they say they've realised they've forgotten to add accounts on, and they attach all the accounts, and my learned friend took the
So
witness to as well.
in 2019, a Riverbank account would have been with the CBA.
Yes. Can we bring up GWC 001 007 0357? And this is the document we looked at before. It has the paragraph down the bottom of the page, and then there's a CBA Riverbank, Australian dollar Riverbank account attached to it. But the witness has said he didn't see the attachments, so.
I'm sorry, what were you asking this witness about those 2014, 2015 letters and attached statements?
So the first question was regards the cover letter and the changes made on the cover letter to include the reference to the directions. And then the second change was the addressee of the letter. And in that evidence, the witness confirmed that he only saw the draft cover letter but not the attachments to the back of it.
But is there anything you want to add to that now, Mr. Hume?
I have to say I'm a little confused with all of what's gone on here. So, no, I'll leave it as it is. Thank you.
Right.
Thank you. On this letter that we have up on the screen at the moment, the August 2019 letter, your evidence you gave before lunch was that what precipitated this letter was a meeting between yourself and Mr. Preston and Mr. Murray.
That's correct.
Correct. Was Mr. McGregor involved in that?
No,
No, sorry, it was
no
not.
he's in Melbourne. So, whether he had received a call from Mr. Preston separately, I couldn't tell you.
And did you take over drafting these letters after this August 2019 one was sent out?
No, I retired 3 months later. Yeah.
Okay. Just one separate topic. You pleased to know we've left the letters now. Regarding your interactions with the GWC, you described before the break, or you agreed with the proposition that you were the conduit between the department and the GWC.
Yes. Not the only conduit, but
The primary conduit.
yeah.
And you also described a practice whereby, in my words, you'd socialise submissions with the department before formally presenting them as submissions to the GWC.
We would. So,
Socialise, you would share submissions or test your submissions with the department before they're formally put to
depending
the
on what
GWC.
we're dealing with, we would certainly talk to them. That's evident by the minutes of the DRGL operations meeting. There were some instances where we would provide a demonstration beforehand. Usually it's a submission, then we do the demonstration. It's a combination of things.
Do you consider that your submissions, your formal submissions made to the GWC were a foregone conclusion?
Oh no, never. No, you can't. I couldn't assume that. Given the amount of work I put into some of them, I'd like to think they were approved, but there's no guarantee. I mean, table supervision levels, I knew that was potentially a big and a significant change for the regulator in its thinking. That's the reason we put the extent of the submission that we put forward. Others which are less concerning, they wouldn't be as extensive. But yeah, I think it's fair to say I endeavoured to include as much information as possible to enlighten the Commission and hopefully persuade them to approve them, but there was never any guarantee in my opinion.
Okay, thank you. No further questions, submissions.
Thank you. Any other applications? Are there any council who are in a remote location who wish to ask questions? No?
Just one, if I may, Mr. Hume, you referred to in your early role in 94 to 98 as Senior Regulatory Officer, developing risk-based audit programs.
Yes.
I'm just keen to understand how those programs were developed. Did you have any expertise in that, or did you draw on some other existing materials?
I hadn't been exposed to them. I had a pretty sound understanding of casino operations. I relied on the teachings of the Deputy Director General, who used to work for an audit firm in Singapore, for him to explain to me and the Chief Casino Officer the methodology and the approach to that, and I learnt from that.
Very
and
good.
That's where I got that from.
Okay, thank you.
Thank you.
Mr. Hume, I've just got one question for you. In your early period, you know, in that 1990s
Yes.
period, you were a government inspector
Yes.
at the casino, and sometimes inspecting the cage.
Yes.
Did you, in that capacity, physically attend junket buy-ins and junket settlements?
Government inspectors broadly, and I couldn't give you the timeline when they stopped doing it.
I'm asking, did you
Yes, I did. Yes.
attend junket buy-ins and junket?
Settlements.
Settlements?
Certainly, I remember the settlement side of things.
All right. Now, can you tell me, and I hope you can do this in a short time frame,
Thank you.
but can you tell me physically
Yeah.
what did the government inspectors see and do in the process of supervising or overseeing, or whatever word you would like to use it, the junket settlements?
Okay, so there was a summary report that was kept by the cage that I can recall. There was often a series of documents to do with the transactions that took place. So chip purchase vouchers are an example of those documents. My recollection is we would look at them, just add them up. You knew what their turnover was based on that. You'd look at the program that they had agreed to. There's a documented program. It entailed a percentage of commission to be paid to those junket operators. We would calculate it separately to make sure the casino operator was only paying that due commission based on those programs. And that was about it, really. We'd take away a copy of the settlement sheets ordinarily, get a photocopy, and they were retained.
And at some point, government inspectors ceased to be physically present in the cage during junket settlements. Is that your understanding?
I don't know if I was around then, but I have heard that when I returned to the inspectorate in 2006, I noted that the role of the government inspector in a lot of activities within the casino where, for example, our involvement in equipment control had been removed, no longer being in the count room where the revenue's counted, and I was advised that was a decision of the Commission to divest the inspectors from being actively involved in those elements of the business.
Well, I think then that you would not be able to, tell me if I'm wrong, but you wouldn't be able to comment on the differences between the physical activity of the government inspector when the government inspector, as you were,
Yes.
physically present for
Yes.
junket settlements,
Yes.
and the period where the government inspectors were not physically present, that you couldn't comment on the
No,
differences?
I probably couldn't know,
All
but
right.
other than to say audit programs were in use.
Thank you. Commissioner King.
Thank you. Mr. Hume, in relation to the process for whereby patrons were permitted to withdraw funds at the hotel or
Yes.
and obtain a chip purchase voucher.
A receipt. They got a receipt at that stage.
They got a receipt which they then exchanged for a CPV.
Well, they took it to the cage and got whatever CPV or cash or whatever they.
I just want to know what is your understanding of the use, the advantage of that procedure?
I haven't turned my mind to it, to be honest with you, and I never really did whilst I was working at Crown.
That's fine. In 1994 to 1998, when you were developing the risk-based audit program, you acknowledged that you hadn't had any training apart from what you received on the job from
Yes.
then manager.
But also understanding the casino industry, which is pretty unique.
Yeah. So, was any document created by the regulator in which the risks, historical, current and emerging, of casino gaming were identified and listed?
Not that I can recall.
Was there any document which recorded the risk appetite of the regulator in respect of those risks?
Not that I can recall.
Were there formal risk assessments prepared in relation to each of those current and emerging risks?
Not that I can recall.
And in the areas where you've listed, there were audit programs prepared. I note that there's no audit there of the responsible gaming program? Was there any
There
reason
wasn't
for that?
one back then.
Was there any reason for that?
It probably wasn't in the foremind of everyone at that time. Well, certainly not mine anyway. The chief casino officer was very astute in that regard, and the fairness of games was an important part, making sure, but no formal RSG.
And I also noticed that there was no audit of the AML CTF program at the casino. Is that right?
I don't remember that being in
And
place back then.
Is there any reason why? Well, so you don't remember such a program that is an AML CTF program existing?
I remember
back then,
something
that might be fair.
$10,000 coming in many years ago, or $5,000, but that's all I can recall.
Can I ask you whether you had any role in August of 2019 in preparing the presentation for the GWC in relation to a variety of matters? It might have been a PowerPoint presentation.
About what, sorry?
So it was, so can I refresh your memory if you have one, that on the 21st of August 2019, Mr Connolly sent to Mr Preston and yourself and Mr Murray an email in relation to GWC presentation 27 August, and he said that he was keen, it was addressed to Mr Preston.
Yes.
And it said that he was keen to get Mr Preston to present to the Commission on some of the issues relating to the allegations reported in the media about junket operators, players, and key processes that Crown has in place.
Without seeing it, I'm pretty certain I wasn't involved in that, without seeing
All
it.
right. Well, if you're pretty certain about that, I'll leave that then. In relation to the casino manual, did you have an understanding when you were compliance officer at the casino as to the enforcement procedures and powers, I suppose, that the department, the GWC and the casino control officer had in respect of the casino manual?
Oh, yes, there's penalties and prosecutions and non-compliance, and people can lose. There's regulations associated with staff losing their licence, being censured.
In particular, did you think that the casino licensee could be charged with an offence for breaching the all of the provisions of the casino manual, or only some of the provisions of it?
Well, I'd have to think. I'd have to think and look at it closer to give you an answer to that. Sorry.
Whilst you were the compliance officer at the casino, was the licensee ever charged with an offence for breaching a provision of the casino
I
manual?
can tell you the Commission decided to prosecute Crown back in 2010 over an incident. And do you want me to go through that?
Was that the one where the minister then
The
determined no?
Crown received a fine of $3,683 from the courts over a matter to do with non-compliance with ex gratia procedures contained in the casino manual. The Commission determined to take Crown to court in that regard, and I'm intricately aware of that whole thing because as soon as I heard what had happened over the weekend, I reversed the decision that was made on the Monday.
Right. So that's...
But ultimately, the Commission still chose to prosecute Crown.
Right, so that's an example.
Yes.
That's one example,
Yes.
2010.
Yes.
Are you aware of any other instances?
Yes, there's been a number of instances where not so much Crown but the employees and executives have appeared before the Commission for non-compliance. That's not so much in the latter years. I'm pretty pleased after we had done a lot of work to ensure compliance, but when I first started, the first 5 years, it was really quite busy. And I remember a roulette incident, for example. There was about 7 senior and seven table staff having to appear before the Commission with a threat of potentially losing their licence.
Right, I'm just focusing at the moment on
The casino
actual
licensee.
prosecutions.
Yeah, no, the only prosecution that I'm aware of, albeit I've heard there's another one about a juvenile, but I don't know any details about that.
So the 2010 one is the only actual prosecution
That's
you're
correct.
aware of. Thank you. You said that it was your expectation that all potential AML instances would be brought to the compliance
Yes.
committee. If gaming staff were regularly seeing bill stuffing occurring at
What do you mean by bill stuffing?
patrons going to a fully automated table game
Yes.
and inserting up to the maximum number of
Yes.
bills
I think it's
into the
$2,000 if I recall correctly. But yeah.
and then either with little or no play
Yes.
removing the money
Yes.
and leaving the casino.
Yes.
Would you expect such a matter to be brought to the attention of the compliance committee?
Yes, and it was. There was a lady that was known to be doing that. Without getting details of who that patron was, I was aware that the AML team were, as I understood it, reporting that particular lady accordingly.
So that's one instance, and is
Yes.
that the only recollection?
That's the only one
you have?
that comes to my mind. Yes.
But your view would be is that if that was happening
Given-
regularly and the staff were putting it into their shift reports, then it should have come to the compliance committee ultimately.
Yes, and given that one got reported, I'd like to think others would too by the staff involved. Most of the staff endeavoured to do the right thing, from my experience. They
And
might make
so-
mistakes.
So are you saying that by virtue of the fact that those sorts of reports to the compliance committee were unusual, if not rare,
Yes,
that in your view it did not occur out at the Perth Casino?
I couldn't say it didn't occur. All I can tell you is that there was only one instance that I can recall. Any matter of non-compliance from an AML was reported as we walk through one of the examples today. Yes, that's all I can say.
Now, going to the Riverbank account,
Sorry, just adding to that, and I did mention earlier there was, and I don't know how Crown got involved in this, but that rather large cash exchange at the Cage, which did get reported from an AML perspective and did have the police involvement.
do you recall being told in 2014 that the Riverbank account at the ANZ was closed because the ANZ had concerns that the account was being used to launder money?
I didn't get that level of information. I just seem to recall Claude mentioning that a bank account was being closed. Now, I can't remember the specifics around that. It was just
so-
like a passing comment.
Just so that I can
And
get some
Mr.
idea about the
Timing.
role of the compliance committee. Do you think that the compliance committee should have been told of that sort of thing in relation to an account used by the Perth Casino for wagering, gaming? Sorry,
The Compliance Committee.
Yes.
We wouldn't ordinarily be told of that, but I would have thought if there's anything untoward that might be occurring, it should have been reported to the committee.
So to the extent that
Given-
that would have reflected the fact that there was something untoward going on at the casino,
Yes,
the Compliance Committee should have been told.
yes, yeah. Having said that, if there was some matters that were confidential that didn't go to the committee but went to the Executive Risk and Compliance Committee, there was one or two of those matters, if I recall correctly. We touched on them, but we did delve into the details. But they did go to the Executive Risk and Compliance Committee, and they weren't AML related, there were other matters.
So going on to a perhaps different aspect of the same topic, do you recall being told in 2015 that ANZ had been advised through a promontory report, who I understand are consultants, that there were deficiencies in Crown's AML CTF procedures with respect to the Riverbank account?
A report from a consultant?
Yes.
No, I have no knowledge of that.
And if indeed the ANZ had passed on to, I'll tell you who it was, to Mr. Barton,
Yes,
that there were apparent deficiencies in the AML CTF program,
yes,
which related to the Perth casino.
yes.
Do you think that the Compliance Committee should have been told of that?
Or at least, if we weren't, because it may have been confidential, I don't know, but at least it should have been escalated to, given that the process was from Compliance Committee to the Executive Risk and then to the Crown Board. I would have thought Mr. Barton's at the board level. He should have brought it to the board's attention. Absolutely.
Going that way, but
Yes.
going the other way.
Whether
so
it would have
as-
fed the other way, I doubt it.
But you and the Compliance Committee would have been keen to ensure that that the Perth Casino's AML CTF program was
Yes.
tickety-boo.
And given that where Josh sat amongst the hierarchy, I would have thought he'd be aware of those matters, and it seemed to me Josh was endeavouring to do what he could in that space.
One of those things would have been to tell the Compliance Committee, wouldn't it?
Yes,
Those
potentially, yes.
And then moving on to another topic, in relation to your friendship with Mr. Connolly.
Yes,
Now, given that Mr. Preston and Mr. Connolly also had some kind of
emails.
social relationship, I'll put it like that, do you think that it was appropriate that Mr. Murray obtain permission, so to speak, from Mr. Preston for yours and his relationship with Mr. Connolly?
From my understanding, he took it further than that. He took it to Barry as well. Whether he mentioned my name in that discussion, because I do recall him saying he would speak to Josh about him and myself. But yes, that's all I can know.
Did you go out fishing with Mr. Connolly whilst he was at fisheries?
No. It was probably, until the latter period, it wasn't a friendship like you would have friends coming to your home with their kids or anything of that nature. It was a work-related friendship. Having said that, I probably progressed that a little bit further because I got to like Mick more by inviting him to my home once I retired. And equally, we went to a fishing club with our wives.
So am I right to infer from your evidence that you don't, even at this point, see anything wrong with the relationship you had with Mr. Connolly?
Sitting in my seat, potentially no, provided my management's approved it. From a regulatory perspective, if I was sitting in that role, I may have a different view.
In respect of the removal of junket approvals,
Yes.
did you find out subsequent to GWC's consideration of the casino's submission that in fact all of the junket regulations were repealed rather than just the requirement for pre-approval of junket operators and junket representatives?
I think it was the regulations being repealed first. That's my recollection. I think we may have got a letter from either Santo Menino or Sandy Del Preti to advise us that the regulations have been appealed or something like that.
Did you
and
appreciate
consequently-
that as a consequence of that, not only was the pre-approval provisions repealed, but also the requirement to actually advise GWC of the fact of a particular junket occurring had also been repealed?
I think our letter undertook to advise them, or I can't remember. I can't remember the specifics of that. Sorry.
In respect of how that came about, you say Mr. Preston came to you
Yes.
and said that other casinos didn't have this
Yes.
requirement for pre-approval, and that junket operators didn't want to go through the police interview process and were so choosing not to come to Perth.
They didn't want to go through all the administrative process of filling forms in, going to interviews. That's as it was described to me.
And you knew at that time that junkets were notorious for involvement with organised crime?
On a personal level, no, I didn't. You could come to that conclusion. As an individual, to see the level of money that they can and do spend, but some of these, as I understand it, are very high net worth individuals. And whether you see on a day-to-day basis the average tradesman coming in with X amount of money with cash, is that money laundering too?
All right, so the bottom line is you say you weren't aware of that at that time.
No.
And so when Mr. Preston spoke to you about this, and you apparently did internet searches about what AUSTRAC and
No, what
Others did?
customs and...
did you do an internet search to see what junket operators did and whether they were had any connections with crime and
No,
crime
I
gangs?
didn't, but I do recall an article that I saw in the paper some years ago about Macau and Crown at that stage engaging with a junket operator, and the article suggesting he was a rather unsavoury character, which I did forward through to the executives.
But at the time you prepared that submission to
No.
GWC,
I didn't
you
do
hadn't done any
anything
of
more.
that sort of
No.
research.
Bear in mind that the AML team have a process by which they would check, I think it's called World Check or something, I don't know how good or deficient that is, to do some level of checking, but no.
And tell me, the last matter I wanted to speak to you about, if it was relevant, is whether you had any role in preparing the letter dated 7 March 2019 to Mr. Ord in relation to the amendment to the WA appendix to, amongst other things, reduce the speed of play
Yes,
of EGMs.
yes, there was a combination of myself, Claude, James Sullivan on the technical level, Lonnie, Josh, I think even Barry Felstead, looking at that letter. But as a principal writer, it was myself, James and Claude.
So did you consider that that letter was consistent with what you've described, I think, as the open, honest and transparent relationship with the regulator and the casino?
My view of being open, transparent relates to where there's something gone wrong within the casino, non-compliance. My job was to put submissions to the casino as required by the business. Some I may not have agreed with, but equally my job was to prepare submissions on behalf of Crown.
So
I wouldn't do anything illegal or put misinformation in there purposefully, if that's what you're thinking.
no, well, what I was getting at was that the letter says that for the reasons detailed in this submission, Crown Perth is of the respectful view that certain factors within clause WA 4.2 of the WA Appendix commercially disadvantage Crown Perth against other casino operations.
Yes.
Now, it's true that the letter didn't bring to the GWC's attention matters which might in fact make the Perth Casino commercially, or give the WA Casino a commercial advantage over other casinos, did it?
No, I don't know whether it did or didn't.
Well, do you have
I couldn't tell you whether it gave an advantage. All we did was compare speed of play, RTP and other jurisdictions.
So it didn't, for example, include any comparison of tax rates on EGMs between jurisdictions?
That's a good point. We should have considered that.
And it didn't mention the fact that in Perth, the Perth Casino has a monopoly on the EGMs as opposed to interstate casinos.
No, that's true.
And it didn't include any analysis of EGM revenue at Perth Casino as opposed to other casinos.
Well, I'm not sure where I'd get other casino revenue, but yes, if that's available.
Or you would have had Melbourne Casino revenue available to you, wouldn't you?
Yes, potentially.
And the letter says that a comparison of gaming machine standards applicable across other casinos in Australia has identified the following key factors as creating a significantly less favourable and uncompetitive operating environment for Crown Perth, and it then refers to speed of play and return to player. Would you agree with me that without including some of those other factors that I've referred to, that statement is potentially misleading?
Look, you can always write something better in hindsight, and it just wasn't matters I considered, or others actually. If it was considered, we probably would have included it.
And then in respect of the final portion of the letter, which relates to responsible service of gambling, and the letter says that it's of the Crown's of the respectful view that the proposed amendments will not have any impact on gambling-related harm. I know it's probably a very minor matter in your view now, and you may not have a recollection of it, but do you recall who's drafted that? And
look, I was listening to some of those words and I'm thinking, did I put them in? I can't recall. It's quite strong in some of its terminology. Whether I'd put those words in or others, I can't recall.
I mean, in fairness to you, I think Mr. Preston's evidence before the Commission is that when the oral presentation was done, he changed that to negligible or small, but that's actually, the letter is as I've quoted it to you. I just wanted to ask you whether, to your knowledge and recollection, Crown did any analysis of what the impact would be of the change on gambling harm before it wrote that opinion?
No, I don't recall it doing that at all. No.
Thank you.
Thank you. Anything arise?
No, thank you, Commissioner.
Mr. Hume, if you were legally represented, your counsel would now have an opportunity to ask you questions by way of clarification of issues that have arisen or matters that may have may need to be added to.
Yes.
So if I'd like to give you the opportunity now to, and perhaps you might like just to take a few seconds to think, is there anything that you want to tell us by way of clarification or to supplement what has been said?
Not really. I hope I've probably talked too much, I suppose, a little bit, but I hope I've been given enough information and been honest and transparent with what I've did. That's all I can say.
All right, thank you.
Thank you.
Mr. Hume, your testimony has been of assistance to us, and we're grateful to you for that. In case there are matters that need to be tidied up, we will leave the summons in place, but you're free to go and to resume your post-retirement
Thank you.
life with our
Envy.
With envy, yeah.
envy, with our envy.
This is the. I'm actually going away again soon,
So thank you very much.
so I just thought I'd let everyone know.
All right, well,
Thank
we'll,
you.
Thank you.
We will resume at 10 a.m. tomorrow, but just before we do, tomorrow's witness is Mr. John Alexander, who is a director of Seven West Media Limited, as I understand it. On previous occasions, I have made made statements concerning particularly the evidence of Ms. Marini Fuster, who has responsibilities to that board, about my association with the chairman of that board, and those statements are repeated. But for now, we will adjourn and resume at 10 a.m. tomorrow.
This